Section 26. Admission of a party. The act, declaration, or omission of a party as to a relevant fact may be given in evidence against him. Section 27. Offer of compromise not admissible. In civil cases, an offer of compromise is not admissible of any liability and is not admissible in evidence against the offeror. In criminal cases, except those involving quasi-offenses, criminal negligence, or those allowed by law to be compromised, an offer to compromise by the accused may be received in evidence as an implied admission of guilt. A plea of guilty later withdrawn, or an accepted offer of a plea of guilty to lesser offense is not admissible in evidence against the accused who made the plea or offer. An offer to pay or the payment of medical, hospital, or other expenses occasioned by an injury is not admissible in evidence as proof of civil or criminal liability for the injury.
Section 28. Admission by third party. The rights of a third party cannot be prejudiced by an act, declaration, or omission of other, except as hereinafter provided. Section 29. Admission by the co-partner or agent. The act or declaration of a partner or agent of the party within the scope of his authority and during the existence of the partnership or agency may be given in evidence against such party after partnership or agency is shown by evidence. Other than such act or declaration, the same rules applies to the act or declaration of joint owner, joint debtor, or another person jointly interested with the partner.
Section 30, the admission by conspirator. So, the act or declaration of a conspirator. So, the act or declaration of a conspirator relating to the conspiracy and during its existence may be given in evidence against the co-conspirator. So, after the conspiracy shown by evidence other than such act or declaration. So under the section 30, so conspiracy is the act of one, is the act of all. So the admission of the conspirator or the judicial admission of a conspirator can be admitted as evidence against the other conspirator. Section 31 is the admission by previous, so where one derives title to the property from another. So the act of declaration or omission of the latter by holding the title in the relation to the property is evidence against the former. So for example, if there is a registered owner of a property and there is a tenant or a worker that he allowed uh, the worker or the tenant to work on his land, and he gave the tenant a small portion or share of his land. So in case the owner will die, all of his property will go to his successors or heirs. So in that case, the heirs cannot deny the right of the tenant that the original owner allowed him to work and stay to his property. So the declaration of the previous owner cannot be used or evidence by the worker against the heirs.
Section 32. Admission by silence. An act or declaration made in the presence and within the hearing or observation of a party who does or says nothing when the act or declaration is such as naturally to call for action or comment if not true, and when proper and possible for him to do so may be given in evidence against him. Section 33. Confession. The declaration of an accused acknowledging his guilt of the offense charged or of any offense necessarily included therein may be given and evidenced against him.
Section 34. Similar act as evidence. Evidence that one did or did not do a certain thing at one time is not admissible to prove that he did or did not do the same or similar thing at another time, but it may be received to prove a specific intent or knowledge, identity, plan, system, scheme, habit, custom, or usage, and the like. Section 35. An accepted offer. An offer in writing to pay a particular sum of money or to deliver a written instrument or specific personal property is if rejected without valid cause, equivalent to the actual production and tender of the money, instrument, or property.
Number 5. Testimonial knowledge. Section 36. Testimony generally confined to personal knowledge, hearsay excluded. A witness can testify only to those facts which he knows of his personal knowledge, that is, which are derived from his own perception, except as otherwise provided in these rules. Example of this is when a person witnessed a shooting incident. As he is now considered as a witness, the only thing he can say are the things that he saw in his own perspective, such as how the suspect shoot the witness, how many are they, and how did they kill the how did they manage to escape. The other thing, such as what he hear from others and he tried to say it on the investigation, can be considered as a hearsay because that from him or her, but from others.
Exception to the hearsay rule. Section 37. Dying Declaration. The declaration of a dying person made under the consciousness of an impending death may be received in any case wherein his death is the subject of inquiry, as a evidence of the cause and surrounding circumstances of such death. Example: Juan stabbed Ana. While Ana is conscious but almost dying, the police seized her and asked about the incident. Ana declared that Juan stabbed her. The statement of Ana is an example of dying declaration.
Section 38. Declaration against interest. The declaration made by a person deceased or unable to testify against the interest of the declarant. If the fact asserted in the declaration was at that time was made so far contrary to the declarant's own interest, that a reasonable man in his position would not have made a declaration unless he believed it to be true, may be received in evidence against himself or his successors in the interest against third person.